Gentlemen, the Law Society is quite strict in its rules that speakers can only be introduced once. Hence, I will not be further introduced to you and just move into my lecture in the materials. And the topic that I am dealing with is special will drafting problems. And what I intend to do is to expand upon a number of the areas that I've covered in the paper. A number of them I won't deal with because I've had an opportunity in the paper to thoroughly deal with them, and to raise with you a few others which, because of space restrictions, I didn't have an opportunity to deal with in the paper itself. Let me point out to you, of course, that the great advantage of taking on a topic such as special will drafting problems is the fact that there are literally, as I'm sure you'll agree with me, hundreds and hundreds of special will drafting problems. I have very selfishly chosen those which I have found to be special problems, and you may, all of you may well find that none of these are problems to you at all, and hence the whole purpose of this exercise on my part has been to educate myself. If that's the case, well, at least one of us has benefited from the time today. You will also find as I go through these, particularly the ones I'm going to cover today, that I have stressed areas which have created a fair amount of litigation over the last number of years, very much falling back on a principle I believe in very sincerely and definitely, which is nothing helps you as a draftsman as much as being involved in the litigation of wills, and you have an opportunity to look at somebody else's mistakes and problems, negligence or error, and that gives you the opportunity to alter your approach accordingly. Having said that, the area that I first want to spend some time with you this morning discussing is what I've called avoiding the litigated will. Now, anytime I've discussed this, whether in the bar admission course or programs such as this, I always get a few tongue-in-cheek remarks about why avoid the litigated will. It being recognized perhaps by some as the best form of estate planning for lawyers. But I think when Gord Hill is finished with us today talking about the area of negligence in our field of practice, estates and trusts, and the changes that have occurred in a very short space of time, the last few years, and the extent to which solicitors in this area can now be held negligent, and he'll be, I know, dealing at length with cases like Whittingham and Crease and Ross and Conters. I think once we have heard that, we will all agree that we, as draftsmen, have to make a very great effort to keep the will out of court. Of course, that's not a matter completely within our control, but I'm going to suggest to you today that it is a matter which is to a great extent within our control. And I predict to you that it's not going to be very long, I would think within the next couple of years, that we are going to be reading a report of a case where a solicitor is being sued by a beneficiary or a trustee who is claiming the costs of litigation, whether on an interpretation, whether on an effort to find a will to be invalid for one reason or another, whatever. And that the action is going to be for the very substantive costs, which, as we all know, often are attracted by estate litigation. Incurred, it will be alleged, as a result of the drafting error or the error in judgment when it came to taking instructions or whatever on the part of the solicitor. With that in mind, let me first talk about the area of the challenge to the validity of the will and just what we can do as draftsmen to avoid this. And there are really 3 points, and I'll make them fairly briefly. And to some extent, they may be criticized as being counsel of perfection, but I don't think they really are. The first is that, if at all possible, we should have the wills executed in our offices, and we should get instructions directly from the testator. Self-evident. However, we all have busy practices, and the circumstances of the situation may not allow us the luxury sometimes of easily getting a testator in to sign the will or to take instructions directly from the testator. We have all, I'm sure, been placed in that position one time or another where instructions must be taken from another member of the family. I point out to you, while it can't be done all the time, particularly in light of cases such as the ones I just mentioned, it's important that now more than ever we make an effort to get the testator into the office for purposes of taking instructions and for execution of the will. Now, if we can't, then number one, as far as execution is concerned, Ross and Contras is very, very clear. Send out a memorandum to the testator with the will, setting out precisely what the procedure is to be followed on execution, and just as importantly, what could occur, including invalidity of certain provisions in the will or invalidity of the will itself in the event that due execution is not carried out in the manner set out in the memorandum. Very important. It's not enough that you send the memorandum. The memorandum has to contain a warning to the testator about what occurs if the will is not properly executed. As far as the matter of instructions, I am well aware that we can't always get instructions directly from the testator, but we must try. And while I'm sure almost all of this audience has had an opportunity at one time or another to read the case of Ree Worrell, which I cite in the material, a decision up in Simcoe County, it's not a bad idea every couple of years or so to reread that case. It's a very humbling experience of just what can be said in the context of a court judgment about procedure used in a lawyer's office for taking instructions and execution of the will. You read Ree Worrell and the very damning nature of that judgment to the solicitor, and think for a moment that you would not want that kind of decision being written about you. Second point as to challenge to validity of the will, and to some extent Mike Fitzpatrick has already raised this, but I think it's worth repeating, and that is that if you have any doubts or reasons for concern about questions of testamentary capacity or undue influence or any of the other matters that can affect validity of the will, then prepare a memorandum. Have a memorandum done by you and by your secretary if she's the other witness to the will. You should spend a fair amount of time, if you can, with the testator so that you can set out in the memorandum what kind of conversations you had with him or her, the length of time you spent, the areas covered, the kind of responses you got, etc. I'm assuming now that you've got some concerns or there may be circumstances in the family situation which leads you to have some concerns, but you're reasonably satisfied that the person has testamentary capacity. Nothing can be more embarrassing to a solicitor than to be dragged into court with respect to a will that he's drafted after someone has died and admit that, yes, he prepared the will, and yes, he was a witness, and yes, he knew the person had had this problem and that problem and some psychiatric history, and he knew that there was a problem within the family, but no, he didn't do a memorandum because it's not really his practice and there was no reason to do it, and as far as he can recall, yes, the fellow was all right. At very least, we will find ourselves severely criticized by the court in that situation, and based on comments I just made and the way the law is going as far as negligence is concerned, embarrassment may just be the beginning of our problems. As far as the evidentiary benefit of that memorandum, needless to say, it is extremely important. So I'm not just talking about self-protection. In terms of protecting your client and making sure that you have done all you can to prepare for him not only a well-drafted will, but a valid will, and a will which can resist challenge to its validity, prepare the memorandum, have your secretary prepare a memorandum, even if all she says is, because she may just be in for a couple of minutes, you're not going to have her sitting there while you have a general discussion with the testator. But even if her memorandum says no more than there was nothing untoward about the meeting and there was nothing unusual and the man certainly seemed to understand what he was doing, when you get into court, that's very important. And these points, I submit to you, are even more important today when more and more we have beneficiaries, heirs at law, attacking estates as word is disseminating, as it were, that they can almost do so with impunity. Our courts now, with rare exceptions, as you know, are prepared to, almost in a knee-jerk way, if I can say that without being disrespectful, to grant costs, at least party and party, out of the estate. The court has to be pretty much affronted by what the beneficiary is alleging, or potential beneficiary, heir at law, before it's going to deny costs in a challenge to a will. So we have more and more of these cases coming to light. And the third and final point I want to make on the area of the draftsman and challenge to a validity was that alluded to by Mike about the doctor. And if you do have concerns, or if you think that the family may, because of the testator's condition or medical history, be potential attackers of the will, then speak to the testator about getting something from the doctor, about speaking to the doctor. Now, anytime I mention this, people quite understandably point out to me that obviously that's a very difficult and sensitive area. How do you broach with the person that there may be some concerns about his testamentary capacity and you'd like to speak to his doctor about it? I have found that if you take it from the point of view, if you develop it from the perspective of pointing out to your client that there are all kinds of ways that wills can be attacked by all kinds of people, that can delay the estate, that can cost the estate money, and for his own protection and for the estate's protection, and to ensure that what he wants to happen in the will does happen, what you would like to do is simply contact the doctor. Even a short letter from the doctor to keep in your file can be extremely valuable ammunition to snip in the bud any potential attack down the road when the testator has died. That's as much as I want to say about the question of the validity of the will and what the draftsman can do about it and protecting it. I want to turn for a couple of moments now to protecting the trustees. As draftsmen, we so often appoint the trustees. We, of course, tell the testator to speak to the people he said he wants to name as executors and trustees, and we give the trustees all kinds of discretion. End of story. And then one day, as it seems will happen to all of us, the testator is no longer there, the trustees step forward and assume their role as trustees. We have moved, it seems, over the last few years to very much giving our trustees broad discretionary powers. Mike alluded to some of these in an administrative sense, in a dispositive sense. And I'm more concerned right now with the dispositive provisions, but I have concern about the administrative ones as well. I think that we have to give very broad discretion to our trustees. The economic times themselves demand that, and there are many other reasons as well, of course. However, I simply commend to you as draftsmen that we can, I think, provide a great deal of assistance to the trustees and keep them out of court and keep them away from snapping beneficiaries if we go on in the will or in a memorandum to give some indication of what perhaps the concerns of the testator are. That when he gives this discretion, what kinds of things is he thinking about? As between spouse and children, what kind of balancing has he got in mind? Now, all of this can be done, I suggest to you, in a very safe way with our provisions about without in any way limiting the generality of the foregoing, etc., and without tying the hands of the trustees or limiting the discretion we've already given to them, but assisting them in knowing what the testator was intending, to leave them with what is sometimes a very significant amount of money, and perhaps even more importantly, where it's not too significant an amount of money, and a difficult family situation, and they're told, you've got the discretion, do it. Take care of the children, take care of the wife. I think once in a while we've got to step back and question just what kind of situation we're actually creating, and whether it wouldn't be a lot more helpful if we, at least having done that, go on to provide some guidance as to what the testator has in mind, what his concerns are, what kind of balancing. I'm not suggesting limiting how he can use the funds, but giving him some direction. Somewhat along the same lines, as far as discretion is concerned, that there should be a provision in the will, I suggest to you, indicating to a trustee who has a great deal of discretion about disposition of the estate among a number of beneficiaries. There should be a provision pointing out that it's recognized by the testator that that carrying out this discretion by the trustee may well benefit one beneficiary over another, and may well result in one beneficiary being much more favorably treated in the estate than the other. I've included a draft clause in the material which does indicate that as being contemplated by the trustee, by the testator, I should say. And again, I'm not suggesting that the trustee doesn't already have the discretion to do that, nor am I suggesting necessarily that the beneficiary could upset an exercise of discretion by the trustee in favor of one beneficiary over him. However, to, again, assist the trustee vis-a-vis both beneficiaries and the court, I've included that clause for your consideration. I want to turn for a moment under the heading of protecting trustees to the matter of compensation. I think most of us have had the experience in administering an estate where the estate goes relatively well and no serious problems. You get down to the end and you have the question of trustee compensation and whether it is a situation in your estate where all your beneficiaries are sui juris and hence you can have compensation agreed to by beneficiaries, or whether there is some beneficiary who is not sui juris and you must pass your accounts. In either of those situations, you find suddenly you've got a problem. It's not that unusual where you find that your most difficult aspect to the estate is in fact the question of trustee compensation. I don't think it fair, particularly when it may be a matter of an estate being administered over many years, when we don't say anything to our trustee about the problem with compensation. We may tell him, her, they, it at the outset that they're entitled to compensation, and then 2 years later they come along to try to get it as the estate's being wound up and there are all kinds of problems, and now you're saying to your trustee, well, it would be a good idea if you could provide a summary of what you've done in the estate over the last couple of years. Rather, what I'm suggesting is tell your trustee at the outset, keep a record of what he's doing, some of the services that he's provided. The courts, for the most part, don't require trustees to put forth time dockets, but it's not a bad idea to have time dockets. These kinds of things can help justify the trustee's compensation claim. Compensation agreements are not widely used in this jurisdiction, but certainly available to us, and it's something that I point out to you as a possibility. I refer to an article by Rodney Hull in my paper on the subject of compensation agreements, where the testator and trustee agree how much the trustee will take by way of compensation. It obviously makes that issue a non-issue. The important point there, if you are going to have an agreement as to compensation, then it must be incorporated into the will. Otherwise, it is not binding. One final point of compensation. doesn't really relate to this lecture and drafting, but because it's a fairly recent development, I just want to mention it to you, and that is the question of pre-taking compensation. It has been the practice in this jurisdiction, particularly by trust companies, over the last few years, to pre-take compensation. I'm not talking about setting aside a sum of the estate for a reserve, but actually appropriating a certain sum on account of compensation and actually using that as the trustee's monies, taking that in advance of a passing of accounts. Despite the practice in Ontario, there have been Western cases, Prelitsky, Wellborn, which I refer to in the material and cite there, both of which have disapproved the practice of taking compensation and have held the practice to be improper in British Columbia and Alberta. Very recently, about 6 or 7 weeks ago in Ontario, there's an unreported decision, which I'm sure will be reported, of NOCH, K-N-O-C-H, decision of Her Honor Judge Diamond, where Her Honor followed those cases and for reasons set out in Her Honor's rather lengthy reasons for decision, disapproved the practice of pre-taking compensation in Ontario and has found that practice to be an improper one. So the trustee can take a reserve and ensure that there will be something at the end from which to claim compensation. The trustee cannot take something ahead of the passing of accounts or agreement among all the beneficiaries. Still under the heading of protecting the will from litigation, I want to address for a couple of moments the question of dependence claims, claims under Part 5 of the Succession Law Reform Act. As I mentioned in my paper, although we all still see wills where someone has felt that even though he doesn't want his wife to take anything from the estate and he doesn't want to leave her anything, he'll leave her $1 because somehow he has the idea that if he leaves her $1 as opposed to nothing, that she will be disentitled to make any claim against the estate. All of us in this room, of course, know that isn't the case. Thankfully, though we may criticize our law from time to time, it's not quite that nonsensical. And rather, the Succession Law Reform Act looks to the issue of what is adequate provision from the estate. And in Part 5, of course, there are many, many criteria which are set out for the court to make that kind of assessment as to what is adequate provision for the dependent claiming. Just 2 points for the draftsman in terms of protection of the estate from the dependent. Perhaps 3. The first is by preamble. The first goes along with Mike Fitzpatrick's comment that it behooves all of us to pursue with our client, the testator, what the family situation is, who is out there, who may not be included in the will, who may have some claim, or who may feel that they have some claim. Obviously, if he tells you that he is cutting out 3 of his 5 kids, you've got some information. Very often, he will not mention to you that there might be a child born out of wedlock or another relative who he is, in fact, supporting in some way and who could qualify as a dependent under the Act. This is something that we have to pursue to some extent with our clients. Having pursued it, first point is the definition of dependent under the Act is a 2-part definition. It firstly refers to persons by relationship to the deceased as falling into the class who are dependents. Spouse, former spouse, common law spouse, child, brother, sister, mother, father. All of these individuals are dependents in terms of the relationship. However, they must meet a second branch of the definition, which is that they must be persons who were receiving financial support from the deceased, or persons to whom there was owed a legal, persons to whom a legal obligation of financial support was owed by the deceased. If there is anything about this potential dependent, quote unquote, that would take him or her out of that definition, that information may well die with your testator, and it's going to be of little use to the estate in defending the claim. That information should be gleaned at the time of preparing the will and included either in the will or in a memorandum so that it can be brought to the attention of the court in the event that the claim is put forward, or that it can be brought to the attention of the claimant himself so as to try to stop the claim before it even incurs much in the way of expense for anybody. Second point arises from the provision of Section 69C of the Succession Law Reform Act, which provides that the court is to accept as evidence when considering a dependent support claim, among other things, any statement in writing by the deceased explaining his reasons for not making adequate provision. So, for example, if there is somebody who would fit the definition I just referred to of dependent, but for the fact that the deceased says that she's receiving some support, but really she's financially independent and she just inherited this amount from her brother's estate, any reasons such as this, any inter vivos provisions that the deceased has gratuitously made, which would help substantiate the case of the estate against such a dependent claimant, should be included in written form because they can be presented to the court and, according to Section 69C, are to be accepted by the court as evidence, and a very important piece of evidence. As I mentioned in my notes, you don't get involved under 69C with problems of the rule against use of hearsay evidence because of the fact that the statement is not being introduced to prove the truth of it, but show the thinking of the testator at the time or his intention. Just want to talk for a moment about claims against estates, or really just to say, I suppose, two things in passing, because these are really comments somewhat akin to those about dependents. I don't think I have anything in the material about claims against estates. I just want to point out two things to you as draftsmen and as people involved in the administration of estates. Remember sections 69 and 70, at least remember they exist, in the Surrogate Courts Act, which set out optional procedure when there is a claim against the estate. Summary procedure, which is available when one of these many claims that seem to come out of the woodwork when somebody dies arises. It is a quicker and less expensive procedure which is available. The only problem with it is, and it's a very serious problem, that if either the claimant or the estate don't consent to using that procedure, then it cannot be used. It's an alternate proceeding, alternate to the usual issuance of a writ and commencing of an action in that manner. Last point under claims against estates and under this heading about avoiding the litigated will is just a note to keep in mind Section 13 of the Evidence Act. Anytime you have a claim against an estate or anytime the estate is asserting a claim, Section 13 essentially provides that in any action or proceeding by any party against an estate, or in any action or proceeding commenced by an estate against another party, that the other party must corroborate its evidence to be successful, either defending the estate's action or prosecuting its action against the estate. It's a very important provision and can be used very effectively to ward off claims against the estate because, of course, it removes the usual evidentiary balance between plaintiff and defendant and very heavily weighs the evidentiary matters in favor of the estate and gives the estate a very significant evidentiary advantage. Now, up until recently, anytime I've had an opportunity such as today and mentioned Section 13, prior to 1980 it was Section 14 of the Evidence Act, I've always said that it does not apply to dependent support claims. And I still believe that it shouldn't be applied to dependent support claims, but there is a recent case, and unfortunately, I meant to get the citation but didn't, but I can tell you that the case is in the last part of the estates and trust reports, and it's a dependent support case, and in about 1 or 2 sentences, right at the end of the case, the judge, it's an Ontario case, and the judge states that Section 13 of the Evidence Act is applicable to dependent support claims against an estate. Now, it's certainly authority and it can be used. I'm not sure that it's good authority on that point, but in any event, I certainly intend to use it the next time I'm acting for an estate defending a dependent support claim. I want to turn now for a few moments to the question of what I call iron curtain clauses. The problem that I'm addressing here is one that I think a number of you have had experience with, and I think all of you are pretty familiar with. And that is where you have a client who has a client who has relatives or individuals who he wishes to benefit, who are in an Eastern European country or the Soviet Union, what we loosely, although somewhat anachronistically, refer to as Iron Curtain countries. And his concern is that if he passes much in the way of money to these people, that either as a result of very high death taxes or some form of taxes imposed by the country in which the beneficiary lives, or as a consequence of very unfavorable exchange rates, his beneficiary will end up receiving a very small fraction of what is actually sent from the estate. Now let me point out, before I make any further comment, that I am not commenting one way or another on the truth of that belief. I have received from embassies and consulates of the USSR and Hungary and a lot of other countries copies of their constitutions, copies of their declarations of fundamental rights of their citizens, and all kinds of official paper pointing out to me that their citizens receive the money 100%, 100 cents on the dollar, as it were, and there is no taxation, and it's all for the benefit of their citizens. It's difficult to try to persuade someone who is more familiar with those countries than perhaps I am that that is really the case. And in any event, my concern, and I suggest your concern, has to be that you have a testator in front of you who believes this to be the case. Whether or not he is right, you've got to try to address his concerns and ensure that there is no way whatsoever that his concerns will come to pass. One solution that has been traditionally adopted is to replace the sending of cash with the sending of personalty, parcels of goods. I say that loosely, of course. Any kind of personalty gets to the beneficiary for his use, is not apparently confiscated in any way, or no portion of it is taken, and hence this approach has been taken rather than cash. Like a game of chess, what then developed was that the beneficiaries in these countries were then signing powers of attorney, appointing solicitors or an attorney in the province of Ontario to represent their interest and to try to do everything possible to get cash in their hands and into the country as opposed to goods. So the question arises how we draft our wills to give this assurance to the testator that goods are going to get through and that the trustees are not going to be forced to instead send money with the possible consequences that the testator is concerned about. Quickly, I just mentioned a few cases, all of which, except one, are cited in the material, so you don't have to write them down. The first is Chodak, and in Chodak, just this scenario that I've discussed with you occurred, and what happened there in the will, the residue was to be invested, the income was to be used to buy parcels of goods at such time or times as the trustees decided, and the trustees were to transfer these parcels to the beneficiaries residing in the Eastern European country. Along came the attorney in Ontario with all kinds of formal documents showing him to be the attorney of the beneficiaries in the Eastern European country, and challenged that provision and said that the trustees had to send cash if the beneficiaries demanded it, which the beneficiaries were doing through the attorney. The court held that in light of the provision in Chodak, the trustees did not have the discretion as to the amount of the fund to be paid to the beneficiary, only the manner of the payment, and therefore the beneficiary could claim the entire bequest immediately, and it had to be paid in cash. So our attorney prevailed. Pargaliauskas is the next case I want to mention in this development, because like Chodak, there was a provision about buying parcels of goods instead of transmitting cash. But here there was a gift over in the event that the foreign beneficiary died before all of the interest was paid to him. The court decided in Pargaliauskas that the intent of the testator was that only parcels and not cash should be sent to the beneficiary. And when you got to that point in the decision, you thought that you knew where it was going, but it wasn't to be the case, because the judge went on to say that, however, the testator didn't use the language he should have used, and the gift over didn't help, and the court held that since the trustee couldn't withhold payments, that the beneficiaries had vested interests and could call for the entire bequest. So far it's 2-0 for the attorney. Lysiak was a had similar provisions, and the result was the same, making it 3-0 for the attorney. I want to point out that I'm indebted to Mr. Y.R. Bochiuk of Toronto, a solicitor who brought to my attention a very recent case which goes some distance to even the score as between the trustee and the attorney. The case is not cited in my material. It's not yet reported, but the case is the estate of Michael Hlady. It's H-L-A-D-Y. It's a decision of the Supreme Court of Ontario of Mr. Justice O'Brien, and reasons for decision were just released July 23rd, 1982, some 6 weeks ago or so. I'd be very surprised if it's not reported. The important thing here is that as well as the gift over, the clause provided a discretion to trustees, not just whether to pay by parcels or money, but discretion as to whether to transfer any property at all. The trustees didn't have to transfer anything to the beneficiaries. We're back to our question of broad discretion to the trustees. Mr. Justice O'Brien's decision is a little difficult to follow in some areas, but I'll leave that to you. But the important thing is that his finding on this point was that since there was both a gift over and a gift that was completely dependent upon the exercise of discretion by the trustees, the beneficiary couldn't force payment of cash to himself. Now, I've included a clause in my material which I suggest meets the concerns that we have as draftsmen when faced with this situation. There's no magic in that clause. You can draft one that's equally as effective. But let me just point out to you, I think there are 5 essentials that have to be in the clause if you want to be fairly certain that you've fully protected your testator and your trustees. Firstly, and very importantly, there must be full discretion as to whether or not the income and or capital will be paid, a la Hlady. Secondly, there should be a gift over. Thirdly, there should be a statement, I suggest, right in the clause that the interest does not vest in the beneficiaries. Fourthly, a substantive power to the trustee to buy parcels or personalty to transfer, and finally, an expression of the reasons why the testator has provided the approach of sending parcels. Now that last one I'm not suggesting is crucial, but it was referred to in Pargaliauskas, and I think it's helpful to the court because it certainly won't take judicial notice of why the trustee has set it up this way, and hence it's important why the testator set it up this way. It's important that the testator indicate his reasons for this approach. Now, I am over my time, but I know that Al is going to indulge me for 2 minutes to just mention to you very quickly a couple of things on topic of the mentally retarded dependent, or for that matter, any severely retarded dependent who receives and relies upon public financial assistance. Let me just make the main point to you that firstly, the concern of the testator so often in this situation is that there is a means test in many of these circumstances, a means test that is applied by the government agency as to whether or not a mentally retarded individual or another kind of severely disabled person receives public assistance or not. And I'm sure I need not point out to you that the amount of assistance that such individuals require can be very substantial. And that means test would take into account any funds to which that beneficiary was entitled from any source, of course, including an estate. Now, once again, I've got to put a caveat in that I'm not going to comment upon the morality of support of such an individual and whether such an individual should be supported from public funds or from the testator. Obviously, that varies from situation to situation and dependent upon the relationship, etc. I'm dealing with the concern of the testator saying to you that he has such a dependent, he or she is receiving substantial public support, and the testator doesn't want his estate to simply supplant the public support, because nothing that he can provide, that is the testator, in many of these very sad situations, can much help the person or much increase their quality of life or standard of living. And let me just quickly point out to you the case of Barrow, which I've cited in the material, and the Quinn estate, which I've also cited in the material, which go different ways. In Barrow, the court held on application by the public trustee that although there was an effort to create a trust in the will, and the trustee was given discretion as to how much could be paid, income and or capital, for this mentally retarded beneficiary, that in fact the gift had vested, and hence the public trustee, as representing the Department of Developmental Services and Community and Social Services, could claim the full entitlement of the beneficiary immediately, since they were providing this public assistance to offset the public assistance. Quinn goes the other way because the court held that the interest of the mentally retarded child was contingent as opposed to vested and couldn't be called for by the trustee. I commend Quinn to you. I point out to you I've included 2 clauses, one rather a lengthy one, 2 clauses in the material which address this situation and which I believe protect the estate from a claim on behalf of such a beneficiary. Again, there's no magic to the 2 that I've included, but important that in whatever clause you use in this context, number 1, that there be complete discretion for the trustee, not just when income and capital are paid, but whether or not anything will be paid at all. And secondly, I repeat what I said earlier with respect to Iron Curtain beneficiaries, and that is, it's wise to state right in the clause that the interest does not vest. I referred you to one case, Dace, which is reported in the Canadian Estate Planning and Administration Reporter as to dependent support claims on behalf of such an individual. As you know, there is no question that a dependent support claim can be brought on behalf of such an individual in Ontario under Section 65(2) of the Succession Law Reform Act. And in Dace, the claimant government agency did not succeed, and it's a very interesting and instructive case for you to read. Ladies and gentlemen, I thank you very much for your attention. That concludes my remarks, and Al Brule will now pick it up.
You're reading that upside down?
Yes.
Thank you very much, Brian. And in an effort to move along, I'll commence right away and with the different topic, of course, of the subject of trust. Now, while you have your material in front of you, there are a couple of errors in the book that I would like to just correct or elaborate. That's apart from any grammatical errors. And the first one, as I'm looking at a different set of pages, one on page 69 of the book, not really an error, but I don't want to be shocking. Down the second paragraph, and I say, suppose a client has $600 million in assets. I think when I submitted the material was 600M, meaning 1,000, which was an actual case. So if you correct that paragraph accordingly, I think it will make a little more sense in the material. Then on page 65, I refer you to see Form 876. That's also in the second paragraph, and that's with reference to Volume 9 of O'Brien's Encyclopedia, in case you're interested. Well, now, to move on quickly, many people thought that when we got rid of estate tax and succession duty and gift tax, the trusts were no longer going to be very useful items, because so often trusts were designed with tax in mind. And we still have this concept in mind today, and I think there are probably even more opportunities for trusts, and I hope that I will be able to illustrate some of those to you in the next short time. Now, I was participating in a seminar a short while ago, and someone asked one of the panelists, well, when's the time to get into a trust? When should you do it? And while he answered, well, there's really no set time, I thought his answer was good. He said, if you're in the Blue Lagoon age, you're probably too young, and if you're on Golden Ponds, it's probably too late. So, rather important. Well, the notes take some time to set out different types of trusts. I'm not going to dwell on those. You can read them. The one thing that I do want to just simply make a very brief passing comment, and it's referred to but not in any detail, and that is the matter of resulting trusts and constructive trusts. Now, we're getting a whole new body of law on when somebody doesn't have really a trust properly created, but there is one that results as a result of operation of law, and it is held to be a valid trust in favor of someone. Now, we had the Murdoch case out west with the lady who, with her husband, dealt with the farm property, and the courts held that there was a valid trust in favor of her when he proceeded not to leave her any benefits. I would like to refer to you, if you get into any of these particular problems, to the special lectures of 1981, Remedies in Law, and there's a whole section there dealt with by Morris Cullity on this particular section. And these things happen in law more often than we realize, and we can overcome them sometime by proper planning. The simple case is the question of the bank account, the joint bank account. Someone dies, and you ask the question, well, is that a joint bank account with a right of survivorship that belongs to the other joint tenant, or is there a resulting trust in favor of the estate with respect to that account? In other words, did the deceased set up a bank account to simply have another party as a signing person on that account, or did he truly intend that there was a beneficial interest to pass on death. And the mere fact that it's a joint account is often not enough to pass that, and two things are taken into consideration. One, the contributions to the account, and secondly, and most importantly, that whenever you set up an account like that, it should be patently clear on the bank records that there is a right of survivorship in that particular account. Otherwise, we might end up with a form of resulting trust in favor of the person who made those contributions. And I guess we had the famous case years ago, you probably all took in law school, of Niles and Lake on that particular subject. Well, what I'm really trying to illustrate is trusts aren't always just the result of something you specifically create, but they happen in law. And while I don't deal with those two really a great deal in my notes, I did want to refer to you to the special lectures, because there is a great deal of attention paid to those, and the Supreme Court of Canada has rendered a few decisions lately that are rather interesting. Now, I did suggest at the very outset that we still use trusts to defer or minimize tax, income tax primarily, and this is going to be dealt with later by Mr. Shepherd, so I'm not going to get into too much detail. What we're interested in talking about specifically, I think, in the next half hour is the matter of express inter vivos trusts. And I think people are missing a great deal of opportunity by not addressing their minds to these particular types of trusts and what can be done. Let me just illustrate, and most of them, again, are tax saving. Just one that came to fruition. Take the person who has a mortgage on his house, and I'm referring to a specific case involving a dentist. This was. He had $40,000 to pay on a mortgage coming due this past July. And 4 years ago, when we were talking about his plan, he said, well, I would like to set something up so I put $10,000 away each year, and when this comes due in 1982, I'll have the money to retire the rest of that particular mortgage. So I suggested to him, well, all right, you can put it away, but we then explored the situation and found out he had children going to school, and he was using after-tax dollars to look after those children, and which seems rather ridiculous. And I know you're going to be hearing about education trusts later, but just as a matter of saving money, we created a simple trust, as it were, put $10,000 away the first year. The income beneficiaries were the children. The monies could go to them, or you could make preferred beneficiary elections. He paid no tax on the income. The second year the same way, the third year the third way, and the fourth year. And each year he simply funded the trust by loaning the trust and had a demand note. And this year, when the time came to pay the mortgage, he just demanded his 4 notes of $10,000 each, had the money to pay the mortgage, and paid no income tax on the income that was earned along the line, but it helped provide for education for his children at a low rate. So that's just an illustration with some thinking of what trusts can do, even on a short-term basis. Now, there are 3 things that I think that bear just going over, and that is any trust must have what we call 3 certainties. There has to be a certainty of intention to create a trust. There has to be, and this is of course derived from the instrument itself, there has to be a certainty of subject matter. What is the subject matter of the particular trust? And it can be anything at all, but it's got to be ascertainable. And then there has to be a certainty of object, and this either has to be clearly expressed or at least can be determined. Now, once we meet those 3 certainties in creating express trusts as opposed from constructive or resulting trusts, then we have the necessary ingredients to go ahead, and from there we have a great deal of latitude. Trusts can be expressed to be revocable, that is, they can be called off by the individual settlor. They can be irrevocable, in which he settles them and they're there subject to the terms of the trust, or they may be both. They may be revocable as to a particular property in there and irrevocable as to the rest, or they may be revocable as to a period of time and then they become irrevocable. And that is a common trust I'm going to speak to later, the so-called living trust that embodies the individual's assets and management of those assets during his lifetime, but after his death, it really becomes his will and becomes irrevocable. And that does have applications in certain instances. We have the matter, as you may recall, of creating trusts before that had to vest by age 40 with an individual. And that gave us a fair amount of latitude. These were individual trusts under the old act. When that was abolished, we then found ourselves dealing with the matter of the 21-year valuation rule or deemed dispositions with respect to income tax. And for those who are interested in perhaps perpetuating a trust that they wish to create for longer than 21 years, I refer you to the notes where we deal with it. And this could come about perhaps in an individual setting up a trust with shares in a private company, private family company for his family. He wishes this to go on, and if he doesn't do things properly, then in 21 years, even though those shares aren't going to be sold, they're going to have to be valued, there's going to be a deemed disposition, and there's going to be tax to pay on it. Now, there is a suggestion in the note that you might be able to postpone this almost for a period of 41 years instead of 21 years, and because that's rather special, I'm not going to get into it. Going back to our old age 40 trusts, as we call them, it almost became necessary at that time that we set up an individual trust for each of the beneficiaries because they were going to attain that magic age at different dates. And that as opposed to a class trust, wherein we simply put all the money in a so-called family trust, and then the income that can be paid out, maybe the capital too, on discretion of the particular trustees. In other words, if we set up a trust for 4 children and they're all being educated at different costs, in year 1 you can pay all the money to one, year 2 to another, vary it however you want, or you can make preferred beneficiary elections, which you'll hear about later, and do different things. Well, now let's take the instance where we have a class gift and we have 4 children. What we have really done is created 5 taxpayers. As we pay out to each one of the 4, they are an individual taxpayer, and if we accumulate monies in the trust, we have a 5th taxpayer. Now, if we take, and it depends on the amount you're dealing with, and create 4 separate trusts, one for each of the children, then we really have 8 taxpayers. We have one of each of the children as they pay out and one accumulating in each of the particular trusts. So from that point of view, one can do a lot of tax planning with trusts for children to minimize the impact of income tax in each year, all as opposed to a parent taking his after-tax dollars from a high bracket and letting his children use that money to educate themselves. And as I said, if these are set up by simply loaning the monies to the trust, once education is finished or once parent needs the money, as the case of my dentist, he can simply call his note, take it all back, and it's only the accumulations that are there that really belong to the beneficiaries. Now, people have been concerned with the abolition of succession duties, the impact of foreign duties. And this is where in my notes I mentioned the 600 million. I really meant 600,000. Take the situation, and this was an actual case, where this individual believed in investing in the U.S. market, and nothing wrong with that, and turned out he had $600,000 invested in the United States and other assets in Canada. Now, when he died, that $600,000 in the U.S. was subject to a U.S. inheritance tax. Prior to 1978, that was of no great concern to us, other than the fact that you had to pay maybe the $200,000, but we received credit for that as against succession duties, and formerly when estate tax was in place, we received credit for that. And now, in planning, one has to tell the individual that, look, you have this money, your 600 of U.S. assets, because you want to invest there, really to your beneficiaries is only worth 400,000. And I do suggest in the notes, and I won't get into it because it is a little separate, that if those are placed in a trust, you may have a chance of avoiding this extra tax. And I just say you may have a chance, and the reasons are set out therein, so I don't want to dwell on them in any great detail, but one can consider that. The other way is to form a corporation, but again, the U.S. tax authorities are pretty good looking behind the so-called corporate veil, and one has to be careful what one does. The matter of life insurance, I think, is rather important when it comes to the subject of trust. Now, it was mentioned earlier that simply by making a wife the beneficiary of a life policy, we avoid probate, we avoid the need to bring that into the estate, and that's all very good. When we get into any substantial amounts of life insurance and there is a family involved, I like to think of putting it into a trust. Now, for one of many different reasons. First of all, we also avoid the probate. The matter is there. The monies, if we have our wife and, say, 4 children again, the income from that can be divided as amongst those for income splitting. We have, if it goes directly to the wife on death, the $500,000, if that's the amount, and I use that illustration in my notes. And let's say she's very prudent, she doesn't touch that amount. When she dies, there is no spouse living, of course, unless she is remarried, and I'm sure the original spouse wanted to go to his children anyway, and there's a guarantee, if there is in the trust, that it will. There is no disposition, or rather there is a disposition when she dies on that amount if it's invested, and any capital gains would result. However, if that's invested properly in a trust, and if she dies within 21 years and there's a disposition, there is no capital gains tax to pay at that particular time. It's spread out. And if we are particularly worried about assets in the trust that have been invested with the proceeds of the insurance, one can always make a disposition of those assets before the 21st year. So that is rather important. Now,